Welcome back to the legal video series presented by the Law Office of Joseph Abrams. I'm criminal defense attorney Joseph Abrams, and I answer your most common questions about federal criminal law in easy to understand terms. So let's take a look at today's question. Today's video is the first in a two-part series in which I talk about federal extradition cases. Today, in part 1, I discuss the issue of bail while awaiting an extradition hearing. Next week, in part 2, I will discuss challenging an extradition request. So let's talk about bail in extradition cases. Case law has established a legal presumption against bail in extradition cases, in that bail should be granted in only the most extraordinary circumstances when justice demands it. So although there is a strong presumption against bail, it is not precluded by law, and courts will grant bail in some cases. For a fugitive to be released on bail, it must be found that they are neither a flight risk nor a danger to the community, and special circumstances exist in their case. In evaluating a fugitive's flight risk and danger to the community, courts will consider factors that are commonly considered in all bail hearings. As to flight risk, these include factors such as the fugitive's financial means, foreign ties, and severity of the offense. With respect to danger to the community, these factors include the seriousness of the offense, the fugitive's criminal history, and the fugitive's mental health condition. If a fugitive establishes both that they are not a flight risk or a danger to the community, they must further establish that special circumstances exist in their case. These special circumstances must go beyond what is commonly thought of as reasonable assurance of appearance. In other words, they must be extraordinary and not applicable to all fugitives facing extradition. There are no enumerated factors that give rise to special circumstances. Instead, the finding of special circumstances is highly case-specific and within the broad discretion of the court. Further, mindful of the strong presumption against the bail, courts generally require multiple factors to establish special circumstances as opposed to any single consideration. These can include, but are not limited to, the fugitive's need to consult with counsel, the fugitive's good character and close community ties, the fugitive's family circumstances, the fugitive's health and medical treatment requirements, the fugitive's professional status and stature in the community, the fugitive's U.S. citizenship and lack of foreign ties, the availability of flight mitigation measures such as electronic monitoring, the fugitive's age, state of mind, and emotional development at the time of the offense, and the passage of time and changed circumstances since the offense. I must stress again that none of these factors alone are sufficient to support bail in an extradition case. The defense attorney's challenge is to present as many compelling factors as possible in a persuasive and impactful manner to demonstrate the uniqueness of the case. In conclusion, although a daunting task, a fugitive increases their chance of successfully being granted bail by hiring an experienced federal criminal defense attorney who understands the complexities of extradition law and who can forcefully present compelling arguments to the court. This has been criminal defense attorney Joseph Abrams. Thank you for watching and listening. I hope you found it helpful. And we'll see you next time when I answer another of your questions about federal criminal law.